SJC-12230 in the matter of E.C.
Ms. Eisenberg, good morning. Get settled, and then we'll hear from you.
Thank you. Good morning, Chief Justice Gantz and Honorable Justices. Beth Eisenberg for EC, and I'm going to refer to him as the defendant. What I'd like to highlight for the court this morning are two essential points. The first point is if you look at the plain language of Section 16C of Chapter 123, in conjunction with the provisions of Section 17, which is reproduced in our brief at in the addendum at page 63, it's irrefutable that the core mission of Section 16C, whether it's a petition for commitment or the commitment itself, is to restore the involuntarily hospitalized individual to competency through care and treatment. Because Section 17 provides that if competency is restored, the court that has jurisdiction over the facility shall immediately extinguish the Section 16C commitment and return the individual to the criminal court. So that means that notwithstanding the fact that the individual was found and may in fact still be mentally ill, in need of hospitalization, and even in need of the strict security setting of Bridgewater, the commitment is gone. And what that means is that the core mission of a Section 16C petition for commitment, to commit for the purpose of incompetency, is to restore that individual to competency. So when the appeals court held that dismissal of the criminal charge against the individual does nothing to alter the validity of the pending Section 16C commitment petition or Bridgewater's authority to continue to hold the individual on that petition, it couldn't have been more mistaken, and it couldn't have more flatly contradicted the meaning of the statute and that court's and this court's constitutional obligation to construe the statute for a narrowly tailored, legitimate, compelling, important purpose.
Attorney Eisenberg, can you just, I just want to look at Section 6A for a minute.
6A.
Right, and so my understanding is that that allows a person to be retained in...
On a pending petition.
Exactly, so there is a pending petition that, in this case, right? And
Yes.
so how do you get around that?
Well, our position is, and I think we've talked a little bit about this in the brief, is that that provision, that statutory provision, doesn't confer validity on the petition. It assumes the validity of the petition, so that if a petition in and of itself, per se, is not valid, and that's our position here, is that once the underlying criminal case resolved, the petition to commit him for the purpose of restoring him to competency was essentially defunct. It was essentially defunct. And therefore, even though there's a statutory provision that says, individuals who are pending commitment under a petition are properly held, that assumes that the petition meets constitutional standards and satisfies the Constitution's requirement where you're talking about involuntary deprivation of liberty.
Ms. Eisenberg, before we get into the language of 16B and 16C, which is quite difficult, I have to say. Every time I read it, I have a different view.
Well, I understand.
But before we get into that, let me just understand the implications of your interpretation. So if somebody is at Bridgewater and they're on a 16B, and.
On a 16B? Okay.
And the case gets dismissed
Mm-hmm.
before this is 16C. And there's a concern about security. If you file a Section 7, Section 8, there's going to be an interim period where the person has to be released back to some DMH facility. I'm sure you read the amicus letter, to some DMH facility unless they move on a Section 12, because a Section 12, they can't be at Bridgewater.
Right, I mean,
Am I my concern?
I think if under 16B, if an individual is, as I understand the statute, if an individual is committed under 16B, the criminal case is thereafter dismissed. The hospital continues to feel that this individual requires a psychiatric care and treatment in a secure setting, then within that 6-month period that constitutes the commitment period under 16B, the hospital can timely file.
Sure, but what we have is this situation, and it's not your client's problem that there's a communication gap when a case gets dismissed. So I'm not looking at that issue. But if you're running toward the end of a 16B period and the case is dismissed and you've got somebody who needs the strict security of Bridgewater, even if there's a Section 12, there's an interim period where that person might have to go into another DMH facility. Could that have been the intent of the legislature?
I see what you're saying. I actually think that in a case like that, my concern about DMH's position is that it reads as if this kind of situation doesn't come up, and it clearly does come up. And what I would say to you is that there are several factors that militate in favor of the fact that, yes, the individual, if they've missed a filing period, as they did here, if the filing period is too late, and the only option for the hospital with respect to the continued care and treatment of this individual, if that's what they believe he needs, is to refer him for a 3-day emergency hospitalization. It is not at Bridgewater. However, the point of that hospitalization is close observation and treatment, because it's a 72-hour period in which the Department of Mental Health is really looking at that person to determine whether or not they further petition for his involuntary commitment, whether they try and persuade this person and engage this individual to sign themselves in voluntarily, or whether or not they're going to discharge the person at the end of that 3-day period. And DMH facilities have locked units. This court has recognized the fact that DMH facilities have locked units. The amicus letter talked about elopement, which is the term of art for people running away from treatment. But in fact, if you've got, realistically speaking, if you've got a referral under 12A from Bridgewater State Hospital saying this person continues to need treatment, and they talk to the individual at DMH who's going to be doing the assessment of that former patient, don't you think that DMH is going to both watch that person carefully, assess that person carefully? If they have locked facilities, you've talked about that in McGreeny. Newton Wellesley has a locked facility. In a recent appeals court case, Jane Jay, they talked about the plaintiff in that case in a locked facility. So I think that it's true that it is not the same as Bridgewater, that's for sure. However, it's not as if there are not ways and means for the evaluating agency to take careful measure of the individual who has been sent to them on this emergency hospitalization, and from there.
So if Bridgewater thinks that this person should be at Bridgewater, all they would have to do then if we were to go with you, with your defendant's position, with your client's position, is to file a 7B
Exactly.
along with the 16C petition. Is that correct?
Well, Bridgewater clearly missed the boat in terms of a timely petition. So
Going forward.
going forward, then a 7B would be filed after assuming that there was a 12B hospitalization in a DMH facility for that 72-hour period. Am I answering your question?
I'm saying if somebody's been committed to Bridgewater for the 16B, in order to avoid having this happen again, they would have to file both the 16C if they thought that the person should stay, and just in case the case gets dismissed, also a 7B.
Well, I think that's an excellent point, because it raises the question of what happened here. Bridgewater takes the position that it would be pointless paperwork to file a kind of in reserve a 7B. And I think the real answer here is that there has to be a better organized way of communicating when an individual is held on what's essentially a forensic commitment. You know that the person is there because there's an underlying criminal case. And so I think it was incumbent on Bridgewater to monitor more closely what's happening with this case. If you look in the appendix that Bridgewater put together, there's it's called an administrative chronology that Bridgewater has of what's happening to the case as EC goes back and forth to court. And on March 6th, I think it says, on March 6th, 2013, it says, continued no date. Well, that's not correct. It's not continued no date. It may be no date for bringing him back because his presence was waived in the Dorchester District Court the following day when his underlying case was in fact dismissed. And incidentally, had he been brought back to Dorchester District Court instead of having his presence waived, he would have been released from the court at that point. So really, it's the sheer vicissitude of how this case unfolded that this individual is held, more than 2 weeks beyond, well more than 2 weeks beyond the point that had he actually been transported back to court.
Well, with trepidation, though, why don't we get into the language in the statute? Because whatever the reasons might be, as I said before, it's not your client's fault that there's some administrative difficulties in communication. That can't be why we interpret the statute one way or another. And I appreciate that Bridgewater is saying, well, there's duplication here, and it makes no sense, and 16C encompasses within it the 7B finding. Isn't this just a bunch of extra paperwork? But the statute, we have to interpret it. So you look at 16B. 16B can continue after a dismissal. And then you go to 16C, and it says, after expiration of a commitment under 16B. So therefore, 16C contemplates that 16C contemplates that 16B has been in place, and 16B may continue after a dismissal of criminal charges.
But the court must find as a condition precedent to a commitment under 16C that there remains a question of incompetence. If there's no question of incompetence, then I think the legislature, I think a commonsensical reading of the legislature's expectation here is that the 16C is brought on the heels of a 16B commitment where there remains a pending case.
Right, but Bridgewater's position is that language in 16C about also finds defendant incompetent to stand trial, means that that's a situation where criminal charges are still pending, or there's still reason to assess competency and return to court.
As we've argued, it makes no sense. What we've argued is that in order for an individual to be incompetent to stand trial, there has to be a pending case as to which his incompetency is assessed. And so our position is that the way to read this statute, I mean, I think what would happen if the case were dismissed under 16B and there was still a question of his committability, the hospital would file timely a Section 7B petition. Under Section 16C, it's clear that the legislature understood that or intended that there be further commitment only insofar as the court could make this finding of incompetence, and a finding of incompetence has to be tied to an underlying criminal case. It's not a theoretical status that the individual is in.
All right, thank you.
Thank you very much.
Mr. O'Donnell?
Good morning, Mr. Chief Justice and members of the court. Ted O'Donnell for Bridgewater State Hospital. Your Honors, you should affirm the decision by the appeals court in finding that dismissal of a criminal case does not invalidate a civil commitment petition. The way to consider the statute is a dual track. You have a criminal matter and you have a civil commitment matter. Think of the criminal offense in this case as what brought EC to the community's attention. A mentally ill person has a right to be left alone in the community, but the community, as this court recently acknowledged in the Calvaire case, has a legitimate interest in being protected from violent mentally ill people. So if someone comes to the attention of the community through the criminal justice system, which is what happened here, that's when the mental health system truly gets involved with the individual. So in this case, EC is charged in the Dorchester division of the BMC with the offense. And very soon, it's apparent that there's a mental illness problem. So he's ordered for a competency evaluation. He's sent to Bridgewater, he's evaluated, is opined to be incompetent, and then they look into the situation more. You have an allegation of something. You have other things that aren't in the record, and so I won't elaborate, but they consider the interactions with the individual while he's there under the observation period, his history, such as whether or not it's known, and they wrap all those things in, and then there was a petition filed into 16B, and eventually allowed. He was found incompetent, was civilly committed, and the 6-month period goes along. Then at the tail end, he's again assessed for competency. Again, there's an opinion he's incompetent, continues to be mentally ill, in need of involuntary hospitalization at Bridgewater. And so as my sister in her brief it concedes, there was a timely 16C petition properly at the time, and then thereafter the case gets dismissed. Now what do you make of that? The 16B section, well, not so perfectly worded, I think if you read it, it clearly says there can be a 16B commitment if there's a finding of incompetency, or if the charges are dismissed. It says after commitment, which is where all the confusion comes in. If it said after admission for a period of observation, it would be crystal clear. But I think that's what the intent was. And a 16C petition can only follow a 16B if all the factors remain in place, the opinion, that is to say. So it sort of is right afterwards, and the same language should be held to apply. So a dismissal of a case, it's a mental health matter. It was one allegation. It's what brought him to the attention of the criminal justice system. Does it mean he's cured of his mental illness? No. Does it mean he's no longer per se a risk to anyone? No. That could be argued. If we had a hearing, which we would be tasked with proving beyond a reasonable doubt that all the elements of civil commitment are met. So we should have been allowed to pursue the 16C commitment. 16 clearly contemplates continuation following a dismissal of a criminal case. As the appeals court pointed out, you have in 16E, it talks about notices to the district attorney, but those notices aren't required if there's no longer a case. 16F talks about a calculation of a mandatory dismissal date if a case should remain pending while a person's incompetent. But it doesn't say you immediately discharge them upon reaching that date. They would,
Isn't the answer simple here, though? 16C is in place because you have somebody who's been determined not to be competent to stand trial in a criminal case. Now, if somebody has mental health issues and danger issues, is Section 7 and Section 8 hearings. So why isn't the answer that 16C is for people who are found to be incompetent, and then if you're not in that situation, go over to Section 7, Section 8. Let me put aside whether the redundancy makes no sense. Why isn't that just a simple answer?
you mean just to file a 7 and 8, forget about a 16C?
I think 16C, why isn't it reasonable to say 16C exists, is there as part of the statute for when you have somebody who's found to be incompetent, and then you also have to duplicate the findings under Section 7, Section 8. But you don't need Section 16 if somebody is competent or the case is dismissed.
Right, well, those are two different, so if a person's competent, that's entirely different.
you
That's
don't
not the
need
case
it.
here. But if you, at the time we filed the 16C, there was an opinion, he was still incompetent. There'd already been a finding that hadn't been overturned, or revisited by the district court or municipal court. So it was a properly filed. If you only file a 7 and 8, the whole system, if there's a 16C, there's a forensic person that's going to be involved. If it was a 7 and 8, wouldn't. You'd be determinedly determine whether or not he's competent or not. That's under a 16. If it was just a 7 and 8, that wouldn't be assessed. So the whole system depends on, you need to file the 16C to make sure these things occur. There's a notice to the DA, all those things, so it's important.
And I understand all that. I'm making the question more complicated than it is. Why would you have 16C unless it was to deal with situations when somebody's not found competent? Isn't that the whole point to 16C?
Yeah, I agree, Your Honor. And at the time, that was the status of this individual. After the filing, it's a question of timing. So if he had been committed under 16C and the case was later dismissed, that doesn't immediately nullify the commitment. No, it lives on until the expiration date. But this is a question of timing. It was while the petition was pending. So it was properly filed at the time. Let's say the case was dismissed a few weeks before, we would have just filed a 7 and 8 because there's no case. So that would have been a different, handled differently. But in this case, at the time, it remained the opinion incompetent, still mentally ill, still needs to be, at Bridgewater, and that's why that petition was filed.
So you file a 16, then the case is dismissed, and how does the judge adjudicate it? Does he treat it as if it's a 7 or 8?
Yes, that's what happens in practice. Since the appeals court decision, we've been able to cite that, and what we do when it comes up, and it does, we say competency is no longer relevant, Your Honor, and the district court judge acknowledges that. Yeah, the case is gone. Let's just move to, as 16C allows, the 7 and 8 commitment criteria.
You move to amend?
Sorry.
Do you move to amend? Do you have to file an amended?
No. Well,
I know in this case you asked
we-
to amend and you weren't allowed.
yeah. For matters of practicality, it usually works out better if you do. Just so everyone knows downstream, it's not a 16C anymore, it's just a 7 and 8. So it depends, that it's not, I can't give you a hard and fast answer, but constructively, it's certainly just a 7 and 8. Because competency, you wouldn't bother going into it.
Now, help me, in answer to Justice Lowy's question, you said one reason that you wouldn't want to file alternative petitions, and you mentioned something that if it was a 7, it would be, you would need somebody from DMH there?
No, I'm sorry, Your Honor, that I didn't mean to communicate that. No. if it's a 16, it requires a qualified person, the statute, and a certain kind of a person has to be involved in the assessment. If it's just a 7 and 8, it doesn't have to be that kind of a person. It can be someone with different qualifications. Maybe that's what,
But the person who was qualified under 16 would always be qualified under 7, or would not
Yes.
necessarily be?
yes, they would, yeah.
Okay,
They're-
so you would not need to get a different assessment, because the assessment for 16 would be adequate for Section 7?
Yes, Your Honor, that's, yeah. So, and as the appeals court pointed out, with a pending petition under 6, there's no language invalidating it for any reason. You know, it's subject to challenge, certainly. The person has a lot of due process interest, has an attorney, has the right to have an expert of his own to speak for him, and it's beyond a reasonable doubt standard. All those protections would be in place at the time of the hearing, so. But there's no language saying you have a properly filed petition and there's some change in circumstance. Well, that might be subject for consideration at the hearing as to what, if any, relevance, whatever the change is. But there's nothing in the statute to say it's no good anymore. And the problem with a Section 12, it's an application, and it's to a community hospital. And there's a loss of information. There may or may not be an exchange orally on the phone. Now, we've had a guy here, EC, for at least 6 months with all that data. And now he's going to be potentially taken to a community hospital. Here, we think this person might need something. There's a loss of information. The legislature didn't intend that. And in this case, with EC, there was an opinion that he still required the strict security of Bridgewater, something that's just not possible with a Section 12. At most, you'll end up in a DMH facility. There's a loss of public safety there. Not to say anything against DMH, they're just not strict security.
All right, thank you.
Thank you.